Good evening, good evening. My name is Mohammed Faridi, and I am the association's president. My job tonight is easy. It is not to introduce Jed Rakoff. For that, we brought in a heavy hitter, Judge Lohier from the Second Circuit. You'll hear from him shortly. I, on the other hand, have been tasked with three very simple tasks. The first is to welcome you all to our association. We have so many luminaries of the bar, and I don't think I am equipped, and it's not necessary to name each of you individually. Thank you for being here. It means a great deal to our association, and I know to Jed Rakoff as well. My second task is to give some background on the Cardozo Memorial Lecture Series. The Cardozo Lecture was established in 1941 to honor, and I'll quote the report of the committee that established the lecture, to honor Justice Cardozo's love for the law, passion for justice, and sympathy for humanity. The late Edwin Patterson, who chaired the Cardozo Professor of Jurisprudence at Columbia University, wrote that one of Justice Cardozo's most significant contributions to the law was his rare insight into its moral values, his power to penetrate through traditional aggregate of legal rules and precedents, his power to find an ethical justification or lack thereof in the rules, and his judicial craftsmanship in either bending the tough legal rule to meet the requirements for ethical principle or refusing to bend through fear of breaking some paramount value of the law or social or political order. Thus, it is not surprising that this lecture has previously been delivered by among the most distinguished members of our country's judiciary, Supreme Court Justices Warren, Brennan, Ruth Bader Ginsburg, federal appellate judges such as Judge Friendly, Judge Newman, Judge Calabresi, and federal district court judges such as Marvel Frankel and Jack Weinstein. The lecture has been a cornerstone of our association's commitment to fostering a thoughtful dialogue on the moral values of the law, and consistent with that tradition, we could not think of a more fitting person to deliver it this year. We are lucky that the Yankees are not playing tonight, or else I know that Judge Rakoff would have asked for a rain check. We're very fortunate that the prior Cardozo lectures have been published in legal periodicals. And if you have the time, I would encourage you to peruse through them. The most striking thing about all of the prior Cardozo lectures is their consistency in giving an inclusive and equitable meaning to the tantalizingly vague and chameleon phrases such as equal protection and due process. I confess that I have not read every single one of the lectures, but I've read many. And the ones that stand out to me include the ones from Chief Justice Earl Warren, his lecture in 1970 titled, "All Men Are Created Equal." I have a feeling that if he was delivering that lecture this evening, he would swap men with people. He ended his lecture by stating, "It is not enough merely to open the courthouse doors to everyone. The proceedings must be open on equal terms to all who enter. Otherwise, the word justice is a sterile one which cannot command the respect we claim for it." His was the era that gave us Brown, Miranda, Gideon, Shelley versus Kramer, Griswold, and Roe v. Wade, and so on and so forth. I'll leave it to Judge Rakoff to talk about the Supreme Court's most recent jurisprudence. The other lecture that stands out to me is from Marian Wright Edelman, Leave No Child Behind, which was delivered in 1992 in this great hall. And in that lecture, she debunked the popular myths of that era, some still popular today, about children from marginalized backgrounds, the poor, the racial and ethnic minorities. And she stated, as racial strife and hate invade our land again, strong counter voices and actions must answer those who scratch and tear open rather than heal our ever-tender racial wounds. She spoke like a poet and a prophet. And the last one that stands out to me is a lecture by Judge Weinstein that I had the privilege of attending here in this great hall in 2008. And his lecture was titled, The Role of Judges in a Government of, by, and for the People. And in classic Weinsteinian and perhaps Cardozan fashion, he stated that it was important for judges to recognize and accept the duty to help the disadvantaged where the law, reasonably construed, allows such support. He stated, it is appropriate for a judge to ask, does my decision unnecessarily widen the gap between rich and poor, advantaged and disadvantaged? That statement is profound and is worth consideration. Not just by judges, but also by lawyers in public service and in private practice. Is our work enhancing our fundamental aspects, the fundamental aspects of our shared humanity, or is it leading to their destruction? My third and final task is to thank the law firms that have generously agreed to sponsor the reception that will follow this lecture. They are Cleary Gottlieb, Hecker Fink, Fried Frank, and Patterson Belknap, where I work. I'll now turn it over to Judge Lohier to introduce Jed Rakoff.
Thank you very much, and good evening. Of the several dozen very distinguished jurists, academics, and lawyers who've delivered the Cardozo lecture since 1941, less than a handful have done so as trial judges, state or federal. As Mohammed referenced, Judge Jack Weinstein of the Eastern District of New York delivered his lecture in 2008, and 50 years ago, another great federal district court judge, Marvin Frankel, of the esteemed Southern District, spoke about the judge's search for truth. And only a few years before he was promoted to the appellate division, some here might say before he was demoted to the appellate division, Judge Wazanski of New York State Supreme Court held forth on a trial judge's freedom and responsibility. It's really somewhat puzzling that so few federal trial judges have been tapped to deliver a lecture of this stature that bears the great Justice Cardozo's name. If the Supreme Court is the federal judiciary's eldest child and the circuit court is the forgotten middle child, then the federal district court represents the favorite child, the jewel of the federal judicial system. Since the first session of a district court in Lower Manhattan in November 1789, its basic function is as well known in the popular imagination as that of the United States Supreme Court. Now, it turns out that Justice Cardozo himself would almost certainly have been a great federal district judge, and he had his chance. In 1908 or 1909, there's some quibble about this, he was offered a judgeship in the Southern District by United States Attorney General George Wickersham, one of the founders of the Cadwalader firm and a former president of this very bar association. Cardozo declined the offer, citing the low pay. Some things never change. Justice Cardozo's explanation for declining the judgeship was that he had two sisters to support and the annual salary of $6,000, which I figured out was the equivalent of about $199,000 today, was not enough to cover their high costs of living. But barely 4 years later, Justice Cardozo accepted a judgeship on the New York State Supreme Court, which, according to historians, paid far more than the federal salary at that time. Some things apparently do change. Although he's best known today for his appellate work on the New York Court of Appeals and to a somewhat lesser extent on the United States Supreme Court, I think it's fair to say that Justice Cardozo fully comprehended the central role of a great trial judge in developing the law in a way that not only meets the needs both of the particular case and of the recurring problems that prompt it, but also impartially advances the basic demands of justice. The great trial judge understands, as Justice Cardozo understood, that logic and history and custom and utility and the accepted standards of right conduct are the forces which singly or in combination shape the progress of the law. Which of these forces will dominate in any case, Justice Cardozo said, depends largely on the comparative importance or value of the social interests that will be thereby promoted or impaired. And one of the most fundamental social interests, he emphasized, is that law shall be uniform and impartial. There must be nothing in its action that savors of prejudice or favor, or even of arbitrary whim or faithfulness. Today's lecturer, my friend and colleague, the Honorable Jed S. Rakoff, I believe epitomizes the judge whom Benjamin Cardozo surely had in mind when he wrote those words. And it's altogether fitting that Justice Cardozo has been described as your legal hero. He's one of this country's best and best known federal judges, not only because of his incisive decisions, but also because of his courageous role as a public intellectual who shines a light on our legal system. He helps us all better understand the values that animate the best aspects of our judicial system, as well as those failures that inform its worst features. He is a critic, unafraid to help the public broadly understand not only our core legal deficiencies as a nation, but also the public's own central and independent role in advancing justice and upholding the rule of law. No one familiar with Jed Rakoff will be surprised to learn that his recent book, with the somewhat provocative title, Why the Innocent Plead Guilty and the Guilty Go Free, and Other Paradoxes of Our Broken Legal System, starts this way, quote, "A sense of justice is central to human endurance. No matter what wrongs we suffer or misfortunes we withstand, the belief that justice will ultimately prevail is part of what keeps us going. Nowhere is this belief more deeply felt than in the United States." Close quotes. These are the first words of this important book. I would add that in no one is this belief more deeply felt or experienced than in Judge Rakoff. It's that sense of justice fortified by a profound understanding of American law, its possibilities and its limitations, that impels him in virtually everything he does, everything he says, and everything he writes. But he also recognizes, as I do, and as Justice Cardozo once famously said, that the facts drive the law. My friends, the unique superpower of the district courts is their power to find facts, what Judge Rakoff once called the gritty details of a particular case. The law is, he said in an article, first and foremost engaged in the resolution of practical disputes, and if the application of a principle of law to the facts of various cases repeatedly leads to resolutions that seem nonsensical, it's probably because there are other offsetting principles that need to be recognized and have not yet been, in order to arrive at a just and balanced result. Now, it would take me a long time to describe Judge Rakoff's biography and his many, many accomplishments and awards, so let me focus on just a few. He's authored over 1,900 opinions in his day job as a district court judge. And you would think that would consume all of his time, but there's much more. He is a regular contributor to the New York Review of Books. He writes, among other things, about the Supreme Court, and I think maybe we'll hear a little bit about that tonight. He teaches at both NYU and Columbia Law Schools, and he's a member of both the American Academy of Arts and Sciences and the American Law Institute, an organization that is very close to my own heart. In 2014, a decade ago, he served as a co-chair of the National Academy of Sciences Committee on Eyewitness Identification, which led to specific and, I must say, immensely important reforms relating to the use of eyewitness evidence in the courts and by law enforcement. In that same year, this is of some interest to me, he was listed by Fortune magazine as one of the world's 50 greatest leaders. Not clear to me how you make it on that particular list, but I'm sure I was number 51 and just missed the cut. So enough. My friends, it is my very great honor and privilege to introduce the Honorable Jed S. Rakoff to deliver this year's Cardozo Memorial Lecture.
All right, I want to go home now. So that was really a very lovely introduction. Apropos, though, Muhammad's remarks, I do want to remind everyone of the very critical event in our country's history that is coming up shortly, and by that I refer to the World Series. Yes, you're lucky, or I'm lucky, there was no Yankees game tonight. I'm hugely indebted to Judge Lohier for his very kind remarks. However, they're coming to get me. However, he neglected to tell you that in honor of Halloween, his remarks were actually ghost-written by my mother. However, my wife, Anne, who is sitting here, will now come forward and give the rebuttal. I'm very honored and grateful to the association for having asked me to give this year's Cardozo Lecture. By any measure, Benjamin Cardozo ranks as one of the greatest judges in American history. His transformative effect on state common law is evident to every first-year law student. And even when, with universal acclaim, he was appointed to the US Supreme Court, he never ceased trying to bring to the interpretation of the Constitution the same flexibility and focus on the future that were the hallmarks of his judicial philosophy. As he stated in his justly famous book, The Nature of the Judicial Process, quote, "A constitution states, or ought to state, not rules for the passing hour, but principles for an expanding future." Now, this, I'm sorry to say, is clearly not the philosophy of the current Supreme Court, nor, I want to suggest, has it been the primary philosophy of the Supreme Court throughout its history. Rather, I'd like to try to convince you that through much of its history, the US Supreme Court has usually tended to look backward and to use the Constitution as a tool to narrow or override progressive legislation and to deny protection to unpopular groups and individuals. Now, I did not come to this conclusion lightly. It was the wonderful decisions of the Warren Court that first inspired me to become a lawyer. But as I will shortly suggest, the Warren Court was something of a fluke and not typical of how the institution we call the Supreme Court has performed through most of its history, let alone today. So let's take a look at that history. The Supreme Court held its very first session on February 1st, 1790. By the way, a few months after the first session of the Southern District of New York, which brings sort of a new meaning to the old question, who's on first? But in its first decades, the Supreme Court, under the leadership of the great Chief Justice John Marshall, was mainly intent on establishing a broad construction of the powers of the new government and, incidentally, the powers of federal judges, and who could complain about that? Now, true, the court in these early years was also inclined to further the shipping and commercial interests represented by the Federalist Party, led by John Adams, as opposed to the more agrarian interests represented by the so-called Democratic Republican Party led by Thomas Jefferson, but eventually with the election of the Democratic Republicans ranging from Jefferson to Jackson, the composition of the court and its, if you will, economic biases shifted. But what the majority of these early justices of all stripes agreed about was that no recognition should be given to the rights of African Americans or Native Americans because, as they repeatedly said, it was implicit in the Constitution that these groups were inferior. Regarding Native Americans, for example, the fact that the federal government had signed formal solemn peace treaties with various Indian nations was of no moment, since Native Americans were, in the words of the Declaration of Independence, quote, merciless Indian savages. Now, consider in this regard the case of Cherokee Nation versus State of Georgia, decided by the Supreme Court in 1831. Although the Cherokees had lived in the territory that became the state of Georgia for literally thousands of years, ongoing pressure from the white inhabitants of Georgia to remove the Cherokees to west of the Mississippi substantially increased after gold was found on the Cherokee land in 1828. However, back in 1791, the new U.S. federal government had signed a treaty with the Cherokee Nation regarding certain lands in Georgia to the exclusive occupation of the Cherokees. So when Georgia, in reaction to this gold rush, began passing laws designed to assert state authority over the Cherokees, strip them of their land rights, and otherwise effectively force their removal, the Cherokee Nation appealed to the Supreme Court to void these laws. In response, Chief Justice Marshall, writing for the court, began his opinion by saying that the initial question was one of jurisdiction, or as we might say today, whether the Cherokee Nation had standing to sue the state of Georgia in federal court. The Cherokee Nation particularly relied on the portion of Article 3, Section 2, Clause 1 of the Constitution that provides that federal judicial power extends, among other things, to controversies, quote, between a state and foreign states, close quote. Now, as the first part of that, Marshall conceded that the Cherokees, quote, have been uniformly treated as a state from the settlement of our country, The numerous treaties made with them by the United States recognize them as a people capable of maintaining the relations of peace and war, of being responsible for their political character, responsible in their political character for any violation of their engagements, and so forth. He goes on. But, he added, a question of much more difficulty remains: do the Cherokees constitute a foreign state? In particular, quote, though the Indians are acknowledged to have an unquestionable right to the lands they occupy, can they be denominated foreign nations who can bring suit in federal court? This was an interesting question, but the answer that Marshall gave was nothing short of astonishing. Writing only decades after our war for independence from Great Britain, Marshall declared in effect that Indian nations were colonies subject to the rule and whim of the President of the United States. More precisely, here's exactly what he said, quote, their relation to the United States resembles that of a ward to his guardian. They look to our government for protection. They rely upon its kindness and its power. They appeal to it for relief from their wants, and they address the president as their great father, close quote. And so, Marshall concluded, the court lacks jurisdiction because Indians, in the view of this decision, are just wards of the president and must look to the president of anyone for enforcement of their treaty rights. And when you consider that the president at that time was Andrew Jackson, the great enemy of the Indians, the fabled Indian fighter, obviously the court had to know that he was the last person in the world who would come to their rescue or enforce the treaty rights of his now wards. It should be noted that a year later, in 1832, in the case of Worcester versus State of Georgia, the court, without overruling the Cherokee Nation decision, effectively held that that trying a white Christian missionary in a Georgia state court for state crimes he allegedly committed on Cherokee lands violated the provisions of the U.S. treaties that I've just referred to. And only a cynic, like me, would dare to suggest that the only real difference between these two cases so far as jurisdiction and standing is concerned is that the plaintiff in the Worcester case was a white, non-Indian male. But the broader point is that as a result of the Cherokee Nation case, Georgia felt free to continue to strip the Cherokees of their rights, and with considerable help both from President Jackson and the Congress, this soon led to their forced removal from Georgia over the so-called Trail of Tears, where thousands of them died. Continuing the history of the court in the pre-Civil War era, when the Supreme Court wasn't busy finding clever ways to deny to Native Americans what Marshall had elsewhere called their unquestionable rights, the court was even more busy denying to African Americans their every attempt to escape from slavery. Now, the most prominent example of this is one I know you all know, Dred Scott versus Stanford, but it might be worth taking a moment just to review its facts and holdings. Dred Scott was born a slave in Virginia, but was eventually taken to Missouri, where he was sold to an Army surgeon named John Emerson. As an Army officer, Emerson frequently moved from one Army post to another, taking Scott with him, and as a result, Scott lived for 4 years in the free state of Illinois and the free territory of Wisconsin, where he also met and married his wife, Harriet Robinson, who was also a slave. Both Illinois and Wisconsin had laws that said if slaveholders gave up their right to own slaves, they stayed there for, if they stayed there for extended periods, they gave up their right to own slaves. And so even though Scott and his wife were eventually brought by their owners back to Missouri, they sued there for their freedom, and that suit, which was initially brought in Missouri state courts, was ultimately dismissed without prejudice to refiling, and the case was then refiled in federal court and eventually landed in the US Supreme Court. There, the Supreme Court, in a 7-2 decision authored by Chief Justice Taney, held that any person of African ancestry could never be a citizen of the United States and therefore lacked standing to sue. Specifically, the court held that at the time the Constitution was adopted, the word citizen did not include people of African descent, whether slave or free, because, quote, they were at that time considered as a subordinate and inferior class of being who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to the dominant race and had no rights or privileges. Now, it's been suggested that this was not even good etymology as to what the word citizen meant in 1787. But in any case, the court, having concluded that citizen in 1787 did not remotely include African Americans, determined that it was strictly bound by that original meaning. So for those of you who might believe that the doctrine of originalism originated with justices like Scalia and Thomas, or I guess we should put in a word for Robert Bork, Dred Scott is actually an example of this originalism approach at work with all its obvious shortcomings, and illustrates an approach diametrically opposite to what Justice Cardozo's approach was, as I quoted at the beginning of this lecture. It should also be mentioned that for good measure, the court in Dred Scott went on to say that even assuming arguendo that Scott had standing, he still would lose because these states had enacted their laws pursuant to the Missouri Compromise of 1820, which the court held was unconstitutional because it deprived slave owners of their property without due process of law. As previously mentioned, the holding in Cherokee Nation eventually helped precipitate the Trail of Tears. In the view of many, perhaps most historians, the decision in Dred Scott directly helped precipitate the Civil War. And as a result of the Civil War, Dred Scott was ostensibly overruled by the 13th and 14th Amendments to the Constitution. For example, the very first sentence of the 14th Amendment, enacted in 1868, provides that, quote, all persons born or naturalized in the United States are citizens of the United States. And then, as I'm sure you all know, the same amendment goes on to provide that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So you would have thought that renewed attempts by the Confederate states to subordinate the former slaves would have been promptly struck down by the Supreme Court, right? Wrong. Indeed, The cases in which the Supreme Court of the post-Civil War period made mincemeat of the 14th Amendment are so numerous that I only have time to mention a few. For example, in the sometimes overlooked 1875 case of United States versus Cruikshank, the court reversed the convictions of the murderers of more than 100 freed slaves who had been protesting a controversial Louisiana gubernatorial election. The court held first that the privileges and immunities of citizens of the United States guaranteed by the 14th Amendment only applied to federal rights narrowly construed, so that even a murderous interference with the exercise of free speech and free assembly did not violate the 14th Amendment if it occurred in connection with a state election. And second, the court held that in any event, the 14th Amendment only applied to actions taken by state actors, acting in state-authorized capacities, as opposed to sanctioned organized groups like the Ku Klux Klan. This latter state action holding was reaffirmed and broadened still further in the ironically named civil rights cases of 1883, in which the court held, in a group of combined cases, that the Civil Rights Act of 1875, which provided equal access for all persons to accommodations, public conveyances, and the like, was unconstitutional because Congress had no power under the 14th Amendment to legislate the conduct of private commercial parties like innkeepers or stagecoach companies. So what if the state action was, if the action clearly was state action, as in the case of a Louisiana law requiring that the races be separated while riding on trains? In 1896, in the infamous case of Plessy v. Ferguson, the court upheld separate but equal, which of course was at the heart of Jim Crow's laws throughout the South. Rejecting all constitutional claims, the court held that, quote, the enforced separation of the races neither abridges the privilege or immunities of the colored man, deprives him of his property without due process of law, nor denies him the equal protection of the laws. And what about the application of the 14th Amendment to victims of discrimination other than African Americans? In several post-Civil War cases, the Supreme Court made clear that the 14th Amendment, despite its broad language, applied only when a state government's deprivation of federal rights was motivated by intentional discrimination against African Americans. And going even further, the Supreme Court in the 1875 case of Minor versus Happersett unanimously held that the 14th Amendment, in conferring citizenship on all persons born in the United States, did not thereby confer on women the right to vote, even in federal elections. In an analysis that somehow managed to transfer to the 14th Amendment's reference to the right of citizens, the meaning supposedly given to the term citizen by the original framers of the Constitution in 1787, the court held that when the Constitution was adopted, the rights of citizens did not include the right of women to vote, and that nothing in the adoption of the 14th Amendment indicated that Congress was making any change in the meaning of the rights of citizens beyond simply making those rights available to African Americans. In short, despite that modest event known as the Civil War and the very broad language of the amendments that followed, and the huge changes in American society that followed, the Supreme Court of the United States, in a series of cases in the latter half of the 19th century, managed to turn the 14th Amendment into a nullity. So let's move on to the first half of the 20th century. Having reduced the rights of former slaves to the subordination of Jim Crow, the court now turned its attention to impeding any legislative attempts to deal with the increasing horrors brought about by unchecked capitalism. The same justices who believed that the 14th Amendment's protection of the right of citizens was severely limited in its application felt strongly that among the privileges the 14th Amendment did protect was a citizen's supposed, quote, freedom of contract, which no state could abridge. So the court went on a spree of invalidating state laws designed to protect workers against inhumane working conditions. And it did this in so many cases that, again, I can only take time to mention a few. One famous early example, of course, was Lochner v. New York in 1905, in which the court overturned a New York state law prohibiting bakery employees from working more than 60 hours a week on the ground that, quote, the statute necessarily interferes with the right of contract between the employer and employees, which is part of the liberty of the individual protected by the 14th Amendment. Going even further, the court in the 1923 case of Atkins versus Children's Hospital struck down a District of Columbia law setting minimum wages for women and children on the ground that, quote, freedom of contract, close quote, though nowhere expressly mentioned in the Constitution, was inherent not only in the 14th Amendment, but also in the Due Process Clause of the Fifth Amendment. The DC law, said the court, was therefore, quote, an arbitrary interference with the liberty of contract, which no government can legally justify in a free land. It further followed from this exalted view of freedom of contract that labor unions were a menace. As early as 1908, the court in Lowe v. Lawlord held unanimously that the union's secondary boycott of a non-union hat company in Connecticut violated the Sherman Antitrust Act, as if that act had been directed against unions rather than companies. That same year, in Adair versus United States, the court struck down a federal law that prohibited railroad companies from requiring employees to promise as a condition of their employment that they would never join or seek to join a union. Oh no, said the court, those provisions are part of freedom of contract. Again, these are just modest examples. Anyone who knows anything about the history of unions in America knows that the federal courts led by the Supreme Court were a major tool in efforts to break unions in the decades prior to the passage of New Deal legislation. And that brings us to the New Deal, as is, again, I think generally known. In the early 1930s, the court repeatedly struck down major components of the New Deal that were designed to alleviate the great deprivations of the Great Depression. Indeed, some of these decisions declaring New Deal legislation unconstitutional were unanimous. To some degree, the court's attitude towards such legislation changed after FDR threatened to pack the court, and some New Deal legislation then came to be upheld, although mostly 5-4. It was only after FDR, by serving the 4 terms that would now be unconstitutional, was able to replace a majority of the prior anti-New Deal justices with justices that were more favorable to the New Deal. And only then did the court start regularly approving such legislation. But even then, the court remained staunchly conservative in many other areas and was still capable of such awful decisions as Korematsu versus the United States, where in 1944, at the very time that people were beginning to become aware of Hitler's concentration camps, the court effectively approved the forced internment of American citizens of Japanese descent. Once again, to be an American citizen was, in the court's view, a very modest right indeed, at least for any citizen who belonged to a feared or hated group. Now, as we move my account to the post-World War II period, I suspect all of you have been saying, well, what about the Warren Court? And there's no doubt that the Warren Court took major strides to correct some of the court's abuses of the past, most notably in its 1954 decision in Brown v. Board of Education, but also, and despite considerable public opposition, the Warren Court bravely undertook to curtail police abuse and create protections for even such despised citizens as persons accused of crime. And so we have Gideon, we have Miranda, and so forth. But in terms of the overall history of the court, I think it must be noted that the Warren Court was something of an accident. When Eisenhower appointed Earl Warren and William Brennan to the court, he believed they were reliable conservatives. Indeed, Warren, as governor of California, has supported the internment of Japanese Americans, and Brennan, as a New Jersey state court judge, had issued conservative opinions on numerous issues that made him acceptable to Eisenhower, even though he was a Democrat. That Warren and Brennan would become not only judicially progressive, but also highly influential in changing the direction of the court was totally unforeseen and, to be frank, something of a fluke. Further, the roles of Warren and Brennan in moving the court to a more liberal direction made conservatives determined never to let it happen again. And to an extraordinary extent, they have succeeded. Indeed, long before the recent decisions of what I will call the Trump court, there was the Berger court, the Rehnquist court, the pre-Trump Roberts court, all of which went very far in whittling away many of the progressive rulings of the Warren Court, most especially in the areas of criminal law and procedure. For example, as early as 1983, the court, in the case of City of Los Angeles versus Lyons, held that Mr. Lyons lacked standing, there we are again, lacked standing to challenge the policy and practice of the Los Angeles police to apply life-threatening chokeholds to suspects who pose no threat of violence. The court said that Mr. Lyons, who had been choked almost to death by the police, had no standing to seek to enjoin the policy and practice going forward because he had not shown a sufficient likelihood that he would be seriously choked again. On this rationale, of course, no victim of this putatively unconstitutional practice could ever seek to have it terminated. And it is hardly surprising that following this decision, numerous people have died from being choked to death by the police, the best known example being George Floyd in 2020. More generally, even before the appointments made during the Trump presidency, the court returned to its traditional conservative stance on a broad range of issues, as illustrated, for example, by its 2010 decision in Citizens United versus Federal Election Commission, in which the court held that corporations were people entitled to full First Amendment protections. And even more striking was the court's 2008 decision in District of Columbia versus Heller, in which the court again employed originalism to greatly narrow the scope of gun regulation. As for the current court, anyone who thinks it does not further illustrate my overall thesis about the court's regressive tendencies probably hasn't read Dobbs or Bruin. In short, I submit that what the evidence overwhelmingly proves is that the U.S. Supreme Court has been, for most of its history, a regressive, even reactionary institution, and probably the most reliably conservative branch of our government. Why this is so is a more difficult question, but in the few minutes I have, let me throw out some possibilities. Partly, it derives from the political nature of the court. Unlike, for example, the United Kingdom, where the members of the Supreme Court are nominated by an independent commission. I don't know if you knew that. It's been the law there since 2009. The justices of our Supreme Court are nominated by the president, who inevitably picks people of kindred ideology to his own. And the result is that our Supreme Court justices, whether conservative or liberal, do not, in my view, make their decisions in controversial cases based on anything but their personal ideologies, which they then camouflage through ostensibly rational dialogues. But for reasons I will get to shortly, liberal presidents have, for the most part, been content to nominate middle-of-the-roaders, unlikely to push hard to alter the court's traditional conservative stance, whereas conservative presidents have been more likely to nominate aggressively conservative justices. This, in part, is partly due to the realization by conservatives that in those times when they are outnumbered at the polls, they can still put a brake on liberal legislation by focusing on packing the court. This has been true since the court's earliest days. After Jefferson's Democratic Republicans won the federal election of 1800, but before they took office, the outgoing Federalist Congress filled as many judicial vacancies as they could with reliable Federalists. This led Jefferson to write to his friend John Dickinson, that the Federalists, quote, have retired to the judiciary as a stronghold. There, the remains of federalism are to be preserved and fed from the Treasury, and from that battery, all the works of republicanism are to be beaten down and erased. Now, Jefferson's rhetoric may have been a little strong, but the point remains that conservatives have placed more emphasis than progressives on putting their allies on the court. Progressives, I think, instinctively tend to focus on gaining control of Congress and the presidency in order to enact reforms. Conservatives, while clearly also interested in gaining control of Congress and the presidency, realize that a conservative court will be inherently suspicious of reforms, and therefore that it provides a natural backstop when the conservatives cannot succeed in the elections. In still broader perspective, some of the conservatism of the Supreme Court may relate to the somewhat backward-looking approaches common to lawyers and judges trained in the Anglo-American system of justice. An emphasis on past precedent was originally just a function of the fact that most early English law was judge-made law, and an emphasis on precedent was therefore crucial to providing even a modicum of consistency. Nevertheless, even today, virtually the first thing any judge does when a new case is presented to her or him is to look at the prior precedents, even if decided decades before. If the judge is a lower court judge and the prior precedents appear on point, that's pretty much the end of the analysis, and the case will be governed accordingly. If the judge is a higher court judge, she has more freedom to depart from past precedent, but she often seeks to justify such departures by reference to even earlier conceits, such as the original meaning of the words of a statute. Very few judges adopt Cardozo's approach of adjusting the law to foreseeable future needs. And this is especially so in the federal courts, I'm sorry to say, where so much of the law is statutory and thus less inherently amenable to the kind of restatement that the common law permits. Hence the appeal in federal courts of even such incredibly backward-looking doctrines as originalism. But whatever may be the factors leading to the Supreme Court's regressive tendencies, of the fact that the court has, for so much of its history, exhibited such tendencies, there can be little doubt. If, despite this, the American public has slowly but surely moved in the direction of greater equality, inclusiveness, and freedom, such progress, with only the few major exceptions during the Warren Court, has occurred despite and not because of the Supreme Court. Yes, ultimately the court has come around to accepting much of this progress, although only after many decades of trying to impede it. But compared to other branches of the government, it has usually been the last to come on board. And I see little likelihood that this will change in the foreseeable future. So I am sorry to have offered here so grim a perspective. At the outset, as I said, I have come with great reluctance to this conclusion. But as George Santayana famously said, those who do not learn from the past are doomed to repeat it. I greatly appreciate your kindness in listening to my views. Thank you very much.
Please join us for a reception in the reception area across the hall. Thank you.